Good afternoon. On behalf of your Chicago Dental Society officers and board of directors, I welcome you to today's webinar, Human Resources for Dental Practices in the Age of COVID-19 and the Paycheck Protection Program. My name is Dr. Ted Boris. I'm the CDS Scientific Program Director, and today I will act as your moderator. A few points of business before we start. I'd like to thank everyone who submitted questions which will make up the basis for today's program. You can submit new questions for our speakers by using the question and answer box on your screen. We will address those questions if time permits. The recording of this program will be available on demand on YouTube in about 48 hours. We will be awarding 1 hour of CE credit for this live program, and that certificate will come to you by email. Our speakers today are two local attorneys giving an Illinois perspective to the questions you have submitted. Amy Grogan is a partner with DDS Lawyers and heads up the firm's employment practice.
What's that?
She has broad experience in a wide range of practice areas, including employment law, commercial litigation, and estate planning.
Yeah.
While Amy has counseled a diverse group of clients throughout her legal career, her work with dentists and dental organizations focuses primarily on unemployment-related matters, regulatory compliance, non-compete and non-solicitation agreements, and partnership disputes. She regularly advises both individual practice owners with only a handful of employees and large dental organizations with a workforce in the hundreds. Amy also manages the firm's estate planning practice, advising dentists at all stages of their career to ensure their families are properly protected. Grogan Hesse Uditsky is also a partner with DDS Lawyers and is the leader of the firm's dental practice group. Grogan grew up in a Chicago dental community where his grandfather, his father, and his sister all practiced at one time or another. Grogan started counseling dentists and emerging DSOs when he represented his father years ago in the sale of his practice. He has since become an authority on legal issues facing the dental industry and has represented literally hundreds of dentists and emerging DSOs throughout the country. Grogan regularly counsels his clients through practice transitions as well as the organization of complex ownership structures, employment and partnership matters, real estate transactions, and financing arrangements. Amy and Grogan and the rest of the team at DDS Lawyers have advised countless dentists since the onset of the COVID-19 epidemic. They understand the uncertainty facing the dental community and are glad to be a resource for you as this situation continues to evolve. Now I will turn the program over to Grogan and Amy.
Ted, thanks so much. I appreciate the kind introduction. It's our pleasure to be here and be with you today. And let me begin by thanking everybody, both our clients and colleagues and folks in the dental community for the trust that they've put in our team these past few weeks. Our roots in the Chicago dental community run deep, and our relationship with many of you extends beyond, that of merely attorney and client. And in fact, I think my father is probably listening here today, so I think I better be careful about what I say. So we want you all to know that, we're here for you during these challenging times and understand your frustration with the uncertainty that's surrounding this epidemic. We've heard from so many of you that are struggling with how to address staff and rent obligations and keeping your operations going. So our goal today is really to provide some clarity on how best to handle staffing issues and also how to deal with the loan proceeds under the PPP program to make sure that you maximize forgiveness. So that all being said, we also don't feel that you need us or anyone else to simply regurgitate the law and read the statute to you. Everybody can do that online, but rather to answer specific practical questions that we know you all have about things like handling your staff and dealing with these loan proceeds. So we're going to spend some time initially talking about current HR issues, some hot topics that we're seeing and questions that we're getting from our clients that are affecting the dental industry, as well as some recommendations that we have for maximizing forgiveness under PPP. After which we're going to spend the bulk of the time delving into the questions that you all submitted in advance. And then certainly we encourage you to continue to submit questions during the presentation. And then Ted will relay them to us. So as much as we can, even though this is a large webinar, we want it really to be a Q&A or a conversation similar to what we've been having with our clients over the last several weeks. So with that, I'm going to turn it over to Amy. She's going to start with some of the HR issues. I'll delve into PPP, and then we're going to dig right into your questions.
So I kind of picked 5 topics, which I have seen probably since the beginning of the COVID pandemic, and as dentists were forced to make the terrible decision of having to close their offices. So I kind of picked the 5 that I'm concerned about, as you guys hopefully will all be back at work, and what that means in terms of the new landscape that we're about to have. So the first is, I'm sure you all dealt with or heard about at the beginning, the Family First Coronavirus Response Act, or the FFCRA. And essentially, April 1st, the federal administration put into effect a law that started from April 1st and goes till the end of the year. And in that law, there are 2 different provisions which everybody needs to be aware of, because as you bring people back to work, you are still subject to this law. And essentially, there's 2 provisions. There's the sick leave, and then there's the expanded FMLA. And what happened with all this, and why we're all faced with this, our small law office as well, is it applies to companies that are fewer than 500 employees. So even if you have 2 employees, you're subject to this. Now, that's not to say that the Department of Labor has the option that if there is a reason why, an economic reason why you shouldn't be have to follow the rules of such statute, they can do that, but we don't know what those rules are going to be. We haven't seen, I have not seen yet the Department of Labor, probably mostly because they're overwhelmed, but the Department of Labor come out with any rules regarding who's not going to have to be subject to this law. So I think we have to assume right now that when you bring everyone back, you're going to have to be subject to it, which the first thing is the sick leave. And the sick leave states that you have to give 2 weeks, or really 80 hours maximum, of time at home pay for your employees if they are seeking quarantine, medical diagnosis, have COVID, or they're caring for someone that has COVID, or they're caring for a child who is being schooled at home or does not have any daycare option. So basically, it's a very large population. So especially because it has the caring for the children. So you have to realize that when you bring your employees back, that if they come to you and they say, yeah, but my kid's home and I need to, they're only in 5th grade and I need to help them with their school, that you will be subject to this 80-hour payment while they're quote unquote employed. So what does that mean in terms of if they're not full-time, and a lot of you with dentists and staff, or if they're irregular employees and they don't have full 2 weeks? The Department of Labor just last week came out with a very complicated, for lack of a better word, math equation on how to determine how many hours they're entitled to. And it looks back, which is favorable to dentists, it does look back over a six-month period. So if they were not working during that time period, you get a credit for that. and you won't, the amount of hours that you may have to pay for this sick leave will be much, will be less than the 80 hours. But I'm not going to go into the complex mathematical equation, but if you want to email me afterwards, I can give you kind of what I have now written out, and I think you could figure it out for an employee if you needed to. So that's the first thing you have to be aware of, that as you bring back people, they are entitled to the sick leave up until the end of the year. So they only get it one time. So if you had to give them a sick leave period because you had them working after April 1st, not before, but after April 1st, which I believe most people were shut down by that point, then you can count that. Otherwise, they're entitled to this 80-hour maximum leave. The second thing is they've expanded the FMLA. So now employees 50 and under are now subject to the FMLA, and they also get the 12 weeks. They do get a 10-week or 10 days of unpaid in that 12 weeks, but that's usually covered by the sick leave. So essentially they get a 10 additional weeks on top of the sick leave, and they get to be paid 2/3 the rate of their pay. It is capped at $200 per day and $10,000 total. And it is a little bit smaller in that it is for the care of children or child care and daycare. So it's not expanded as far as taking care of somebody. That's still the regular FMLA. So if you're under 50 employees, you don't have to be subject to that. But it is expanded for employers 50 and under if your employee comes and says they're caring for their children at home. The Department of Labor is coming out with all sorts of new things every day with regard to this act. But right now, the most recent is this calculation on how you're going to have to pay it. And they certainly are enforcing it. So we have had that. Now, there is good news, and I'm going to put that in quotation marks, because if you are totally shut down, you don't have to offer this. And that is only good news in the sense that if we all open back up and then in the fall we shut down again, that doesn't mean that when you shut down, I know we made a lot of decisions on based upon the April 1st deadline to furlough and laid off with a lot of our employees, that you won't have to be subject to it if you shut down. So if you do have to open up and then the government comes and says, yeah, dentists can't work again, and you have to shut your offices down, that doesn't mean you're suddenly going to have to pay 10 weeks. So that is quote unquote good news. So that's the first most important topic to me that people need to be aware of, just because it is a financial burden that you're going to need to know as you bring people back. So then my second topic is workers' compensation. And the workers' compensation topic is that they just came out in Illinois with a rule that there is going to be a presumption that if your employee contracts COVID-19, that they're going to presume that it was at the workplace and subject to workers' compensation. That came out like 2-3 weeks ago. However, and this is a big however, a judge last week put that all on hold and stayed that enforcement of that new rule, stating that he was going to wait till the courts opened back up, because there's a lot of people going, obviously, saying how ridiculous that is to assume that a worker got it at work just because they contracted COVID and they were working. They were even saying that if you were staying at home and you were working from home, there was going to be presumption that you would be entitled to workers' compensation. So I do think that that might not be true, but because rules like this are coming out, what I am going to recommend that everybody do is you need to start communicating with your employees and using best practices in writing and in poster and everything else about the CDC guidelines. What is COVID? What do we want you to do? And obviously, you're going to have a much higher burden being dentists and much higher rules that you're going to have to comply with. but the more information that you can prove that you kept your site clean, that you followed all the rules, is the way that you can rebut the presumption under workers' compensation that your employee contracted it at work. So the more you can put in writing, and I know I'm a lawyer, so I like to say everything should be in writing, the better, and the more communication with workers. And I know you are going to be held to such a higher standard, and I'm sure you're all trying to figure out what you need to do to comply and have a clean workspace, but make sure you document it. Document when you clean the waiting room. Document that you're not putting the magazines out. They don't want you to put magazines in waiting rooms. That, you know, things like that. Document, document, document. Just so that when a workers' compensation case does come up, that you have it all at your fingertips. So then
Amy, we had a question about the FMLA.
Okay.
And it was if we are on week 7 of paying employees 30 hours a week while they're only working 8 or 16 hours, does that count towards the 12 weeks?
So are you saying that you're paying them right now?
Yes.
Okay, if you're paying them now and they're full-time and they're home and you have told them that you're paying them pursuant to FMLA, which is what I want you to correct if you haven't done so, yes, because it's in effect now. So if you have already done that and they're caring for their children or they have children at home, yes, you are totally allowed to use that FMLA credit right now.
However, and we'll get into this a little bit later, right? There's an interaction between the credit you might get on the payroll tax under the expanded FMLA and the PPP program. So you can't get both, right? So you can't get a credit on your payroll tax for payments made under expanded FMLA and get loan forgiveness, for that employee under PPP.
Yeah, but you only have to pay FMLA and sick leave once between April 1st and December, 31st. So that emergency situation, it's not like they can say, oh, you paid the 12 weeks and now I want another 12 weeks because I'm back at work. It counts. So if you're doing full-time pay and you're 2/3 pay, you should be fine. Okay, and then the next hot topic I've seen is these contracts with dentists. And this is much for larger dental offices that have multiple dentists, and they have contracts with dentists in which they have a minimum daily fee. And I think the concern I've seen is bringing back dentists and this minimum daily fee and not knowing how many patients you're going to be able to see in a safe environment and how you're going to meet the minimum daily fee. While people are not allowed to, have dentistry except on an emergency basis at the time to deal with this issue, you need to start thinking about what those contracts look like and what you think that you need them to look like when you go back to work. I've done some amendments on those contracts. We've done some things where we have to even almost terminate, because they all have termination provisions, and so that you can renegotiate them, because everybody wants to be able to have the dentist come back, and everybody and dentists want to come back, but the overburden to the actual dentist office, if they have to meet minimum daily fees and come back in full because they want to get the PPP credit, is going to be a large issue. So because this is so individual and kind of an individual office issue, I just want you to think about that and think about looking at any kind of contracts you have with your dentist and what that's going to look like when you return them to work. And as to the dentists who are being to return to work, you too should look at your contracts and figure out what it is that is going to happen when you return. So I just want everybody to make sure that they are looking at those things, because that's the kind of stuff that falls by the wayside when we're all worried about bringing our employees back, and then suddenly you're going to be in a financial issue. The next thing is what everybody seems to be concerned about, the pitfalls for returning your employees to work. And I found that most of the questions that you submitted were about this, and it's what I'm seeing as well, is what can we and can't we do, and how is this going to look? And so I'm going to just touch on a few things, and then we'll deal with your questions. The first thing is disclosure of information to an employee itself contract COVID. I find that this isn't just a dentistry thing, but all the employers are having employees contract COVID and what you can do. And unlike you, dentists are subject to HIPAA laws, but you're not subject to HIPAA laws with your employees. You still can't disclose your employees' names to other employees or other people in the office once they contract COVID. So it is natural for just to say, you know, John Smith has COVID and you've been exposed and you need to know that. So you can't really do it in that way anymore. It's still a medical record. You don't have HIPAA privacy with your employees. So it's a little bit different. And so you need to know that you can't disclose the name, but you have to go to, you do have to report it to the state agency, and you do have to tell other employees who've been exposed to that person. And you're a little bit different in that you have the PPE, but you may not have the PPE when the employees are sitting in the break room. So that's something that you need to think about, and you need to be able to know who you need to tell, and you can't use names. So that has not changed under the EEOC and under the ADA, and so you have to be conscious of that. The other thing that I think everybody's worried about, and I think I saw it in a lot of your questions, is employees who are fearful of returning to work. And what is going to be hard for you is that OSHA standards say they can refuse to come back to work if they are feeling that they are in a dangerous situation. So OSHA has set the standard is that if they believe and they have pointed out something to you that they feel is a danger to them, such as they're uncomfortable with the PPE or some other part of the way that you're doing the work, they can stay at home, and you do have to pay them. So then you're back to the sick leave issue. So the OSHA standard says that they have to generally believe that it's imminent danger, and a reasonable person would have to agree that there is real danger or serious injury. And so it's this weird standard, but OSHA is coming out and saying that they can refuse if you're not doing certain things. So I think that your best practice is to reassure your employees. Tell them what you're going to do. Tell them all the things that are going to be in place. This is how we're going to practice. I think you're going to get all sorts of rules anyway, or you probably already have a lot of them. I mean, certainly CDC guidelines are out there, but I think that that you're going to get more regulation than you're going to know what to do with. But as that comes out, make sure that you're following it, because that's going to give them a reason under OSHA to say, I can stay at home and I can get paid. The next thing is, can you ask employees to go home? Yes, you can if they have the symptoms, but it has to be the symptoms. You can't just say you need to go home because I think you have COVID. You really have to have the fever, the cough, or otherwise they can claim, you know, all sorts of discrimination and things like that. So I would take temperatures. Certainly anything respiratory you can send them home for, and just be on top of all that. And then there is one that if there's certain parts of your practice, obviously not the dentists and the themselves and the other people that have to be there and actually work with the patients, but if there's a telecommunication option for your other employees and they ask for that under the ADA right now, they are saying that that's a reasonable accommodation. So right now, if your accounting department or other things can be remote, and that's an option for you, and somebody wants that as an option, they can ask for that for a reasonable accommodation. So, and then the last thing is, you cannot ask employees right now, and this isn't going to be forever, but for a doctor's note, for health providers for any kind of illness or respiratory illness, they have now, the CDC has said, it's too hard. you don't have to have that anymore. So they can go home and tell you that they're sick and they have COVID, and they do not have to, you cannot get proof. And then my last issue, and then I'm going to turn it over for the PPP to Jordan, but is the employee and patient screening. So the CDC is changing the guidelines every day. So all you can do is to be on that website and do the best practices you can. I mean, they have posters you're supposed to hang. There's posters you're supposed to hang about the Family First Coronavirus Response Act. There's posters you're supposed to hang about what COVID looks like. Just do as best you can to get all that information to your employees. That's the first thing. The second is I would take the temperatures of the employees. I would and require that before they're working, before they come to work. I think you need to do that for your patients. You don't want your patients to say you exposed them. So I would be taking temperatures. At some point, the CDC is going to tell you you're not allowed to anymore, but as why this pandemic is going on, everybody says that's the best practice right now. As to patients, you need to screen them. You need to update their symptoms, their temperature, their exposures to others. You can ask all those questions before they come in, and you can ask them on the phone. You can ask before they make their appointment, or you can ask, and you should re-ask if you haven't asked before on the phone when they arrive, if they've had symptoms, if they've been exposed to someone, and you can take their temperature. So they are suggesting that you keep people not in the waiting room for very long, and you should not have any magazines, not make it very comfortable. And if you can keep the scheduled appointments with minimum contact, that's what you're supposed to do. So those are kind of the hot topics that I've seen. We'll get to some of your questions that are more specific, but that is what I've seen in dentistry.
Amy, on that note, and I can't recall if this is one of the questions or not, but if a patient does not want you to take their temperature, can you refuse to treat them?
I think that you can make it a requirement. There's nothing that says that I have found, and I did some research on it, that says that you are not allowed to take their temperature. You guys are subject to HIPAA, and so you can do that. You can record it. And so best practices, I think you should almost require it for your employees, because I think then you get into the whole workers' comp issue, and if the employee gets exposed to the patient. So they are suggesting that you do these things. If they refuse, I don't think you can get caught for any kind of discrimination. You're just trying to protect your own employees.
Great. Okay. Well, so I'm going to move on and talk a little bit about the Paycheck Protection Program, and these two topics might not initially seem like they relate, but clearly, they do in terms of the loan forgiveness and what you have to do in terms of paying your employees in order to get the full benefit of the program. So most of you know by now that the loans under the Small Business Administration's Paycheck Protection Program, or PPP, may actually be forgiven if you comply with certain conditions. And if you're thoroughly confused by what those conditions are, don't worry, you're not certainly not alone. I'll do my best to explain what we know today, though as Amy indicated, keep in mind that the situation continues to evolve. And actually the SBA has put out a series of about 20 FAQs that you can find on their website, and that is supposed to be updated at the end of April / beginning of May. So hopefully we have a little bit of additional guidance there. But regardless, we recommend consulting with your respective legal and financial advisors, and also taking a conservative approach to ensure you get the full benefit of the program. As we've all seen, there's been some high-profile cases in the news. We don't think that type of scrutiny is going to be applied to most of the folks on this call who have received likely smaller amounts or smaller loans under the PPP, but nevertheless, we do recommend taking a conservative approach rather than subjecting yourself to some sort of audit. So as you probably know, loans made through the PPP program can be forgiven in part or in full, meaning that you might not be obligated to repay the interest or the principal if certain conditions are satisfied. So to be considered for maximum forgiveness, you have to meet all of the conditions, right? And those primarily are using the loan proceeds during the 8-week period from the day the funds are dispersed, meaning the day you actually received them, for documented payroll, mortgage interest, rent payments, and utilities. So first and foremost, I'm going to start with the rent payments, probably the most straightforward. So any payment of rent you've made under a lease that was in effect prior to February 15th of this year will be considered a qualified expense. Now, there is, and we've gotten this question a fair amount, there's really no guidance currently whether rent payments, or I'm sorry, rent prepayments or payments of past due rent or late fees under a lease would be qualified. At this time, it seems that they would, that there isn't a difference between a payment that was made during the 8-week period but was incurred prior to that versus a payment that was incurred and paid during that period. But given that there's not, that there's limited guidance there, we'd be careful with that if you can. Utility payments generally are qualified expenses and include electric, gas, and water. Internet, telephone, and transportation utilities, they're most likely covered as qualified expenses, but further guidance from the SBA is required. Those expenses are mentioned elsewhere in some of the SBA guidelines, but not necessarily specifically in the CARES Act. Mortgage payments, so principal payments or prepayments are not qualified expenses, but mortgage interest incurred on loans prior to February 15th of this year would be considered a qualified expense. And that also includes not just mortgage payments, but interest on other debt that you may have incurred. So say it was an acquisition loan, say it was a loan for, some sort of like a SERIC or something like that, that you're paying. Those would be included as well in forgiveness. So moving on to payroll, in the issues that we're seeing in connection with what payroll would be forgiven. So during that 8-week period, at least 75% of the total loan amount needs to be used for what they're considering eligible payroll expenses. So that's primarily salary. It would include state taxes. It would include benefit payments. It does not include the employer portion of the federal income tax. So this is something that I know has given much angst to a lot of practitioners, is that you at some point have to make a calculation and balance if your office is closed and you took money and you want forgiveness and you're paying your people perhaps to unfortunately sit home or to do a limited amount of work, you're still going to have to pay that 7.2, or I think it's 7.2% of the employer portion of the federal income tax. And you have to balance that against the 25% in other expenses that you're able to use and be forgiven. So whether it's rent or utilities, et cetera. So no more than 25% of the loan proceeds during that 8-week period can be used for other expenses. So that certainly is a balancing act that a lot of our clients are dealing with as they continue to be shuttered under the Stay-at-Home Act. Compensation payments to shareholders, to members and other owners of borrowers covered as qualified expenses. So yes, there's a caveat here that if you are, say, the sole practitioner in your practice, and let's just say, for example, you're paying yourself, or your compensation is $250,000 a year, right? You can only get forgiveness on $100,000 of that compensation. So you're limited there, but it doesn't matter if you are an owner, as long as it's compensation for services. And that's primarily W-2 comp as well. Just a side note, payments to independent contractors do not count and are not forgivable. Independent contractors can actually apply on their own, and the CARES Act was drafted fairly liberally to allow independent contractors to apply and get funding or get their own loan. But for people that perhaps were either playing games or choosing to try to be treated as an independent contractor, this can certainly hurt them for that. So broadly speaking, comp payments to shareholders, members, and other owners are in fact included. So the big question that we've gotten recently is really, what can cause a reduction in the forgiveness, right? So it's certainly twofold. One has to do with the number of employees, and the other has to do with compensation. Broadly speaking, the number of what they're calling full-time equivalent employees needs to remain the same, and you have to restore that by June 30. So if you have shut your office down, but you've applied for and taken money from PPP, you have to restore your employees by June 30. So you got to bring everybody back. And full-time equivalent, if you have people who are doing 40 hours a week, that's easy, right? You got to bring them back generally for 40 hours a week. If you have somebody that's 20 hours a week, you generally have to bring them back for 20 hours a week. You don't necessarily have to hire those people back for 40 hours, but they are included in the calculation. So you need to bring them back as well. Also, you are not supposed to reduce anyone's compensation by more than 25%. So if you have somebody that's making $40,000, right, you have to bring them back and you have to pay them at least $30,000. Now, some of the questions I've had have been, for example, can I bring everybody back on the 29th, right, and start paying them and comply? And the answer to that is in part yes, in part no. So yes, because that would satisfy the number of employees. However, if you bring everybody back on the 29th, it's unlikely you're going to comply with the payroll portion, which is that you really have to maintain compensation, and your payroll has to be essentially equivalent to what it was before. And again, 75% has to be used for payroll purposes. So if you wait until the last day, bring everybody back, you may have the required number of full-time employees, but you're going to have a hard time complying with that 75% requirement for payroll purposes. And so in those cases, your forgiveness is going to be reduced pro rata. So it's certainly something that we're recommending people consider. And again, you have to go back and weigh out, the cost of the employer portion of the federal income tax and see, does that outweigh paying your people to perhaps sit home or to do limited duties. Finally, record keeping requirements. So there's not a lot out there currently. We're expecting additional guidance in terms of the record keeping requirements and what the SBA is ultimately going to require. You certainly got to keep accurate records and document how you spend the loan funds. You will need to submit documentation of and certify the expenses you paid with the loan over that 8-week period. We've been able here in our practice to set up a separate account where we put the PPP proceeds, and then as we incur them, we're pulling them from one account into our operating account. If you can do that, we recommend it. Many banks would require that the loan funding go into your operating account, so that may or may not be possible. At the very least, you should be perhaps setting up an Excel spreadsheet or some sort of tracking device to actually track the cost, right? Because it's easy to have the money go into your operating account and then forget about it. And 8 weeks down the road, you're going to have to justify that to the bank and the SBA. Which is something else that everybody should keep in mind, is that towards the end of the 8-week period, you're going to need to reach out to your bank and complete some sort of forgiveness application. So likely the SBA is going to publish some sort of form. If not, your bank is going to have something. They will then review your submission and help process your application for forgiveness based on the rules that the SBA sets out between now and then. So you will have to justify the expenses, and we really recommend that you're tracking those somewhere in detail to ensure that you're going to get the maximum forgiveness. Lastly, we certainly understand that payrolls for lots of businesses, including dentists, are going to have trouble meeting the thresholds given the mandated closings. Hopefully that ends soon. It's my understanding that the Illinois State Dental Society, likely the CDS, even some of our clients are lobbying Pritzker, and given what came out yesterday where he had indicated that he never told you guys to shut down. Forgive me for making light of it, but there seemed to be some confusion on his part. We're all hopeful that soon that you all will be allowed to or permitted to open back up. But given these mandated closings, we understand it's going to be difficult to meet these payroll conditions. Unfortunately, under the current SBA provisions, the loans can't be forgiven, whether partially or in full, if they don't meet these thresholds and requirements, regardless of the circumstances. So again, to sum up, we really recommend taking a conservative approach here. There's limited guidance, but keep in mind the spirit of the CARES Act and the PPP program, which is to keep people employed. So we really feel that when the SBA is evaluating forgiveness, they're really going to look at, the payroll side of it, and did you meet that threshold? So with that, Ted, why don't we move into the Q&A and start running through the questions that were pre-submitted. And like I said, as we go through, if you've got questions that have come through the Q&A while we've been chatting, you can bring those up as well.
Okay, I have a couple that have come through. At this point, we can address with regard to the PPP.
You bet.
Who will do the payroll audit for loan forgiveness?
That's a really good question. So, there's been limited guidance there, and we've seen different things come out from different people. So I've seen that the bank is certainly on the application side. The bank was entitled to rely on your certification. But ultimately, we think that the bank is going to do the audit on the payroll side when it comes time to forgiveness. And we're anticipating with some sort of spot audit, ultimately by the SBA. Because the way this works, and this is something that everybody should know too, is, the way that these programs work and the SBA works is the government doesn't come and give the banks the money who then lend it out. The banks lend the money, and then when it comes time 8 weeks from now for forgiveness, the bank has to go and justify it to the SBA, who then gives them, the money. right? So ultimately, the bank is relying on you all and is going to do their due diligence, at least perhaps the smaller banks. I can't imagine whether it's Chase or some of these bigger banks who have tens of thousands, of these loans. I just don't know that they're going to have the manpower to do it. And perhaps to your benefit, in particular on the smaller loans, smaller being perhaps $500,000 and below, the SBA certainly does not have the manpower to be able to audit all of these applications. So it's the bank that's going to be doing the checking, and likely there will be some spot checking by the SBA.
Okay, with regard to employees, you've furloughed your whole staff. Do you have to bring all of them back?
Well, so that is kind of a why HR and PPP interact. If you do not have a PPP loan, absolutely not. Furlough is, you don't have to bring back everybody at the same time. That answer changes if you're talking about loan forgiveness. So assuming that you're not subject to any loan and you furloughed and you didn't take any money from the SBA, then you can bring back, as long as you don't do it in some discriminatory manner, you can bring back whoever you want. Just don't bring back only the men.
Right. And if you laid off or furloughed, certainly you're not required to open back up or to bring people back. However, if you take money or you take a loan under PPP, in order to qualify for forgiveness, right, you have to meet those conditions and bring people back and meet the 75% threshold. Everyone should keep in mind, though, that if you don't meet those thresholds, number one, you can always pay the money back if you don't use it. And number two is, worst case scenario, you have a loan that has a low interest rate, it has a short term, but the money is relatively inexpensive.
Okay, if you have received a PPP loan but decide that an employee retention credit is more advantageous, is that still an option if I return the PPP loan or do not seek loan forgiveness?
Yes, absolutely. So you can't do both, but you can do either one. So if you return the money, you can still get the payroll tax credit.
If we've received the PPP loan and not every employee wishes to return at this time, what is the best way to handle this due to reduce compensation by the 25% employee?
So I guess my question would be, it depends upon who doesn't want to return. If they do not want to return, it's much more for loan forgiveness about the payroll amount. So if somebody says, I no longer want to work, or I found other employment, then you're in a different situation. You can fill that with somebody else. But that's not to say that you can't say, I'm not returning that person and I'm eliminating that position necessarily. So you're kind of in that catch-22 spot.
And this is probably a good time, Ted, one of the most frequent questions that we're getting is, my employees are mad at me because I got a PPP loan and I'm going to either bring them back, quote unquote, right? Which may mean that I don't have work for them to do, or I only have work for them to do, say, 2 days a week. And if they're a full-time employee, I would pay them, but they're now making more money under unemployment than they would be making working for me because of the $600 bonus. So do you want to address that?
So what I want to say is that you cannot get unemployment if you have a job. So unfortunately for them, you can't have your cake and eat it too, right? You cannot, once the job is open and available, they have to return to work. And people are like, well, how do I follow up on that? Well, everybody went, and maybe I shouldn't say everybody, in good times, the Illinois Department of Labor, the Unemployment Office used to make sure that everybody was notified, and you had an option to respond to the unemployment. Go back, find that piece of paper, and that's the number and the contact for each individual employee. And with that, you respond and say, I have offered that employee a job, and I've offered them their job back. And then they're no longer eligible for unemployment.
I've had this question a couple times. Can a sole proprietor pay themselves wages and be considered for forgiveness? Yes, a sole proprietor can pay themselves so long your salary, the person's salary themselves, owners, is subject to the same rules for PPP and the same rules for forgiveness. So a sole proprietor gets the same thing just as if they were an employee. You're your own employee, essentially. Does the 75% on the PPP include normal funding of a 401k or profit share?
Yes, it does. Yeah, so benefits are included. And actually, our controller emailed Amy and I this morning asking about making contributions to a simple plan that we have, and those would be included as well.
All right, I think we should go to the questions that you've
you bet.
previously.
You bet. Why don't we, Joanne, if you want to go to number 2, I think we answered number 1 there regarding unemployment. So if I'm paying my staff through Paycheck Protection, whether open or not, and then officially reopen, but have employees refuse to work, what are my rights under this scenario? Amy, do you want to take this one?
So that's, as we just spoke about, that is the whole thing, that if you reopen and if you offer your employees a job, then they should no longer be eligible for unemployment. So they should come back to work. So that's what will happen. But if they don't come back to work, then you need to fill their spot with somebody else. And they also, at that point, unemployment needs to know that they were offered a job, and then there's no longer eligible. And I think that this will become more and more clear. This is going to be a huge thing in not just your industry, but you know, nationwide, as people open up after, you know, this time period. Jobs are going to be there, and people are going to have to return to work. And
yeah, and I think you have to keep in mind too, because we have had a number of docs who have called us and said, hey, look, my staff's really angry with me. And you have to keep in mind that while that may be the case, you know, that if they are giving you a hard time, then they can blow your compliance with the forgiveness, which means you could end up having to pay back a significant amount of money, right, as opposed to you know, having it forgiven. I mean, if you really feel terrible about it and you want to pay them extra, perhaps you can do that and still comply. But, you know, really, those are people who, in theory, are getting a windfall. And the whole purpose of the CARES Act and PPP is really to get people off of unemployment. So, you know, the government's not looking favorably on that situation. Joanne, oh, there you go. So I have one employee who will not be returning due to health reasons. Can I hire someone else and keep the same number of employees, or do they have to be the same exact employees under PPP? So they do not need to be the same employees. They're really looking at these, what they're calling full-time equivalent. So if you have somebody that's not going to be returning for health reasons, you know, you can hire somebody else. In fact, you really want to try to hire somebody else because of that, again, of that 75% program. At the same time, you also want to be careful. You need to make sure that these are all people that are actually working. I did have somebody ask me if they could put, you know, their son or their daughter on there, and we really, you know, don't think that that's going to fly when a bank looks at that or the SBA looks at it. So do I have to pay all my employees their regular salary? For example, what if one staff member wants to come in more and the others not so much? Can I give her more than her salary while cutting the other employee's salary? So ultimately, you can do this. You know, certainly as Amy indicated, you have to be sure you're not doing anything discriminatory. But the reality is that it comes to number of employees, how many you bring back by June 30th. They're going to look at the overall compensation. And then lastly, as long as you don't cut somebody's salary by more than 25%, right? So if somebody's making, you know, 40,000 and you cut them down to 20 and you pay somebody else more, that's not going to cut it, right? You can't reduce somebody that's 100,000 or less, I should put that caveat in there, by more than 25%.
And I also want to add that in addition, you can't give somebody else more hours and have the other person remain on unemployment, because that's the other thing that's going to cause issues. So if you're doing it because that member wants to come in more, but you have to make sure that where you say others not so much, I would like to have that in writing that they're not just doing that to stay on unemployment.
Right. Now, what you could do in theory, but it depends how your numbers work out, is, you know, let's say you bring one person back right away, but one person you might not bring back, you know, for 4 weeks or 5 weeks or 6 weeks. That can be okay as long as you're still meeting the 75% threshold. So if you can do that and you're still using 75% of the loan funds for payroll purposes, then you might be okay. Let's see, are you required to compensate non-full-time employees even if you do not have work for them to do?
So that's the same. If you don't have the PPP loan, absolutely not. If you do have the PPP loan, absolutely. So it's whether you're seeking forgiveness. So as soon as, if you're not, and you are not seeking forgiveness of a loan, you do not have to, if you don't have work, you do not have to bring them back. Just, even if you furloughed and it can be unequal, and as long as it's not discriminatory, you can do whatever to protect your business. However, you do have to bring back those part-time people in the same way as the full-time people if you want to be forgiven for the PPP loan.
So the next question is interesting. So if an employee refuses to work because you're out of PPE, so personal protective equipment, not the PPP, must you continue to pay them? And this is interesting in part because one of the issues that we've seen arise or that dentists have talked to us about is the supply chain. So, you know, up until now, all the PPE has really been directed to the hospitals and to, you know, physicians, right? So, number one, in order to open back up, you have to comply with CDC, ADA, you know, guidelines, right? But if you can't get masks and gowns and shields, you know, you're in a tough situation. So, Amy, if an employee doesn't want to come back because you're out of PPE, do you have to continue to pay them?
And you do. Under Osha, you have to allow to pay them for sick leave. So then we're back to the sick leave FMLA. So the Osha rules state that that would be a reason a reasonable person would refuse to work. So that is, you're walking that line then. And so I would say that in there that yes, if they're entitled to the sick leave or the FMLA, you have to pay them to stay at home until you are able to rectify that situation and make them feel safe.
And just to be clear then, if they reopen a practice and somebody says, well, I can't come back, I need to stay home, right? You still have to pay them.
Yes, if you have not run out your sick leave and FMLA with them, and they, assuming they're staying home for one of the reasons that applies to that, yes, you have to pay them.
Okay. Our next question. So is COVID-19 a recordable illness for the purposes of your OSHA logs?
yes, right now, Osha is saying that they do want that included in the Osha logs.
Okay. Can you legally check employees' temperatures at work?
And I think we talked about that a little already. Yes, and then actually right now they're saying it is good practice to do so, especially when you're working with the outside. You know, you're expecting people to come in and actually work on their actual bodies. I think you are almost at a higher standard. So I would say that you should check the employee's temperature at work. I know that a lot of employers are doing it where you can even actually record it and do it from home as long as you send a picture and things like that. You may want to do that actually at work just because you're so patient facing.
So are you required to notify employees and patients of potential virus exposure if you have a diagnosed case?
You are. So you are required, first of all, to notify the state, a state health department. And then on top of it, you are required to tell employees, if you're talking about an employee who's been diagnosed, you cannot use names with patients. The dentist, because you're subject to HIPAA laws, can use names for the actual patient. You cannot use names for outside. I guess there was actually a case already where some dentist reported to one of the patient's family members that they had COVID, and that was a big HIPAA thing, and HIPAA said that was okay because it was unnecessary. HIPAA is up for much more for disclosure in regards to COVID. So you're at a high standard for disclosure. Unfortunately, also there is the confidentiality. So you're kind of walking this strange line of using people's names and giving people's information, but also allowing people to keep themselves safe.
So what should you do if an employee falls sick at work or reports to work sick, which hopefully they're not doing?
Right. Well, if you take somebody's temperature and they didn't know, right, you send them home. So it's the reporting, it's what is sick. Right now they're saying you have to send them home, fever, respiratory illness, that sort of thing. So you send them sick, send them home sick, and there's no requirement that they have to get tested, nor is there any requirement that they have to bring back a note. So there's still the 14 days of the CDC guidelines that people should be staying home for 14 days. And so that's when the sick leave kicks in, unfortunately. So if there's a thought, I mean, I hope we all have tests and we'll be able to know whether they have COVID quickly, but assuming that we're still in the state that we are, that it's still difficult to get tests, right now, they're still advising that somebody stays home for the 14 days.
Got it. So if an employee is sick with COVID-19, when can they actually return to work? So that's the 14 days.
That's the 14 days, yep.
How do you handle at-risk employees? So this is a good question that we were talking about earlier. Say somebody's pregnant, they're elderly, other health conditions.
So you're in this situation of discrimination. You have to allow the pregnant and the over 60 person to return to work according to the EEOC, like you have everyone else, but at the same time, you want to protect that person. So because there's nothing under the new FMLA that requires you to pay them just because they're pregnant or over 60 if they want to stay home. You have to offer them the job back, and then you just need to protect them like you protect everyone else. So it's almost a kind of at-risk thing. And if they decide that they do not want to return to work, then you're in the situation where certainly under sick leave, if they don't have the virus or haven't been exposed, they are not covered under that, and they're definitely not covered under the FMLA. So you don't really have to pay them if they're refusing to. But once again, you might not get forgiveness. So you're kind of in a catch-22 there.
One of the things, Amy, that I think we talked about earlier and is further down, but in the questions, but it's probably relevant now. So the expanded FMLA applies to employers with under 50 employees now, is that correct?
It's under 500, but yes.
Or under 500, and there's no exception for the 50. What about the negative impact, in quotes, on the operation of the practice? There was a question I was looking at. I have a total of 5 employees. They're all critical to patient care. The loss of one would have a negative impact on the operation of the practice. I haven't seen, and correct me if I'm wrong, you haven't seen either anybody that's successfully challenged that as an exception?
Right. There's been no successful, and I think that it's mostly because it's just taking long. I am sure that there's some economic, that they'll come up with some sort of economic guidelines where you don't have to pay all this, but you do get, and I guess what you know, the good news, or that you get the tax credit on the other side. So you hope that the tax credit will certainly offset what you have to pay.
Right, and as we indicated in the last webinar that we had done too, is I don't want to be sitting in front of the Department of Labor, right, trying to justify, you know, that in this situation. But you know, if you have to, you have to. But there is an exception if the expanded FMLA would jeopardize the, you know, the ongoing viability of the business. So can you ask employees about COVID-19 symptoms and remain compliant with the EEOC?
Yes, right now you can. I think this will all change once we get through the pandemic, but right now they are letting you take temperatures, they're letting you ask, they're telling you to send them home if they have symptoms or if they have temperatures.
So, okay, we talked about the number 14 already. Joanne, you want to hit number 15 there. How should you incorporate the COVID-19 into your written safety plan?
So this goes to what I was saying, is you need to have this everywhere. You need to be as compliant as you can. I think that what we're going to see next is we're going to see employee litigation, we're going to see workers' compensation litigation, and the more the better. So the more you can put in writing to your employees, the more you can hang stuff up on the wall. Certainly the Family First Coronavirus Response Act needs to be hung already. They're already saying that has to be hung in the break room. So you need to do more than you can, more than you think you should. And you don't need to put it in your employee handbook. You don't need to redo things like that, but you definitely need to make everyone aware. Not that we aren't all aware, but I think that if you can put what you're actually doing in writing, it will just behoove you later down the road.
Can you legally change an employee's duties due to being short-staffed? So our opinion on this is that yes, you can. Obviously, you can't have somebody who's not licensed do some work, you know, say that needs a license, like a hygienist. But you can change an employee's duties if you need to, as long as you're still complying with the headcount requirement and the 75% requirement, and you're not reducing their salary, right, by more than 25%. Is your practice exempt? Okay, we talked about 17. Joanne, you want to go to 18? Who can reasonably work from home? I think we talked a little bit about that as well. Can your employees file for unemployment if you reduce their hours or wages?
Yes, so unemployment has always been, but especially now, on redo will allow collection for reduced hours. So if they're used to 40 hours and you're giving them 10, they can go and seek unemployment for the difference. That's being done now.
How do you handle employee benefits while employees are on furlough or leave?
Okay, so furlough became a new thing. Furlough used to only be the government. And now because of the pandemic, unemployment offices now allow payment of unemployment benefits with furlough. So furlough, the difference between furlough and laid off. So if you lay somebody off, you're not paying them any benefits. When you furlough somebody, you are still paying their medical benefits, or you're paying their benefits, but you're not paying their salary. So while they're on furlough, they can get unemployment. But what you do is then you pay their employee benefits. So you're paying they're still considered your staff. And because you call it furlough under the laws right now, they are still part of your workforce. So they're entitled to your employee benefits. So you pay the employee benefits and then they go ahead and they seek unemployment.
I think we talked a bit about this. To make ends meet, can you decide to make an across-the-board pay cut? So the answer to this is yes and no. Yes, you can, but if you've gotten a PPP loan, right, you just need to make sure you're still in compliance with the 75% payroll requirement. But otherwise, if you're not taking PPP, you certainly can do this if you have to. Keep in mind, of course, unless you've got a contract, the daily minimum fee issue comes into play here. And if you have a contract with somebody, to pay them a certain amount of money, then, you have to keep in compliance with any notification requirements you might have there. And then what happens if I bring my employees back and an employee, a patient, or even me contracts the virus and we're forced to shut down again for another few weeks?
So when you're shut down, you do not have to pay sick leave and FMLA. So if that happens and you have to shut down, you will not have to pay them. If you're trying to get your PPP forgiveness, I don't know if you'll meet the thresholds.
Got it. So Ted, there's a lot of great questions in the Q&A. If you'd like, do you want to go through some of them, or you want me to pick a few out?
If a dentist is an associate paid on a percentage of collections and he receives regular payroll and is a W-2 employee with a biweekly paycheck, does he qualify to be in the PPP loan for the office?
So say that one again. That's if
an associate dentist paid on a percentage of collections.
Got
He's a regular payroll employee and receives a W-2. He's not an independent contractor.
Right.
Does he qualify to be covered under the PPP loan for the office?
Yes, he does. And generally what they're looking at is an average of the compensation then. Certainly would be still covered. And then you have to include an average. When you got the loan for the 2.5 times the payroll, they're looking for an average, and then they'll look at the same thing going forward in comparison to the period that you used for purposes of obtaining the loan.
So what is the FMLA claim or sick leave claim occurs after the period when the PPP loan is spent? Can they still get a tax credit?
Yes, as long as you just can't double dip. So if you got your PPP, you've gotten your forgiveness, we're done. It's now August, it's September, and now they want FMLA. You can give them the FMLA and you can get your tax credit.
When I reopen, I plan to rehire everyone back with limited hours, and enough that they will still get their unemployment benefits. Do they still qualify for FMLA?
So if you're hiring people back, say part-time.
So this is where this average comes up. This is this crazy formula. So what they do is they take and I'm gonna kind of paraphrase, so if you want to send me an email, I can kind of tell you what it is, but they take the prior 6 months from when you decide that they're gonna do the FMLA, or they want that, or they want the sick leave, and they take the prior 6 months, and it's a different formula for sick leave versus for FMLA. But if they're less time and they get that, then they take that at 6 month average, and with you, the average will be much lower because nobody's been working for a couple months. So you hope it's in that 6 month period. And then that tells you how many hours that they get the sick leave for. So your hours will be much less because you guys have all been off. And then they take that, and that's how much you have to pay. So my answer is yes, it's just a different formula. And it's a crazy formula.
And you need to be a rocket scientist to figure it out.
Yeah, right. So if you email me after, I kind of can give you the crazy I can give you a for example kind of formula, but you'll never understand it if I say it out loud.
When you bring your employees back that have been laid off, must they reapply with new forms as a new hire?
If they've been laid off, they do have to you don't have to like necessarily reapply, you just rehire them. But yes, it is kind of like starting over with a layoff.
Can you explain further the requirements for the 10-week FMLA?
Yeah, this one gets, a little bit confusing. I mean, you get effectively 2 weeks, right, of sick leave, and then an additional 10 weeks under FMLA after that, right? So FMLA actually provides, 12 weeks, right? But 2 weeks are unpaid, and then 10 weeks are paid. But under the sick leave effectively provides 2 weeks. So in total, they get 12 weeks of paid leave if they have a qualifying event.
PPP loan forgiveness is based on full-time equivalents, not actual people who are working, correct? That's
correct.
If that is the case, then how does the rule that you can't decrease an employee's pay by more than 25% apply?
Well, you have to look at it, I think, as I indicated, all together, right? So it's full-time equivalent employees. And if somebody doesn't come back or doesn't want to come back, then you don't have an issue. If you bring somebody back, right, on a full-time equivalent, right, you can't reduce their salary by 25%. So if somebody was making 40 grand before, and now you bring them back for the same, number of hours, you can't take them down to 30, right, or less than 30. The idea also is that if you had, say, 5 employees, 3 were full-time and 2 were part-time, if you bring back 5 employees, all part-time, and you're paying them less, you're not going to qualify, right? So each situation might be a little bit different, and if there is a particular situation, please feel free to email us and we can evaluate it. But generally, you have to comply with those conditions.
Under PPP, can my corporation pay rent for a building that I own?
So the answer to that is yes, you can. And in the first round of funding, there was no exception for that. And we don't see that is going to come. Certainly, you have to be careful. You can't increase your rent. There has to be a lease, in place, and it had to have been in place by February 15th of this year. But if you're set up properly and you own the property individually or through an LLC, those payments should still qualify.
If an employee is laid off and then rehired, does the rule that there is a 1-year waiting period for 401ks kick in again?
What's that?
I'm not sure I know the answer to that.
Right.
That one I have to email me and I'll find out.
All right. How long is the extra $600 given in unemployment benefits Or how many weeks are you eligible for the extra 600?
The extra 600, I believe they're saying right now is going to be 4 months, and then then they're going to end it.
Has there been, have you seen any guidance yet, Amy, on the Illinois Department of Employment Security and Unemployment ratings? You know, so far, there's been no movement in terms of how the layoffs from COVID are going to affect your experience rating. In other words, everybody's going to go through the roof.
Right. I mean, right now we don't know. We assume that everybody's going to, the unemployment is so high. I don't know what the insurance companies are going to do because it's a nationwide problem, but they're feeling the pain. So.
Yeah. It's certainly something that's another question that we've gotten fairly often. You know, how is this going to affect my unemployment experience rating? And right now, there hasn't been any relief that's been issued from the state yet.
I have a part-time employee on maternity leave and does not plan on returning until September. How do I account for her position?
Do you want to talk about in terms of whether or not you'd have to bring her back?
Yeah, so I think if she was on maternity leave and she was never going to come back during that time, you are fine. That was in place, and that was the maternity leave that you had agreed to. That I don't think that will count against your PPP issues. So it was however you were going to compensate her or, you know, replace her and how you've done it in the past. So I don't think will be an issue.
That being said, it may in part depend on whether or not she was included in your calculation for purposes of determining the loan, right? That's a little bit of a unique situation.
My employees are still furloughed. I know that at least one employee does not have childcare, and I think she will object to returning to work. How do you suggest I handle this in light of FMLA?
So this is the problem. So this is what's going to happen is she's entitled to, if she does not have childcare, she's entitled to her the right under sick leave and FMLA to get her 12 weeks. Now you do have that it is capped at $200 per day, and it's $10,000 total. But and I don't know how much you're paying her, but she will be entitled to that as soon as you hire everyone back. And you can't really not hire her and hire somebody else just because she has children at home. So it's one of those, you're in the catch-22 that's going to require you to give her that time and pay for it. And get the tax credit, hopefully, on the other end.
Do the 80-hour FMLA payments count towards PPP forgiveness?
Yes, they would, right? But you can't get the payroll tax credit, right? So they would count. But if you want the payroll tax credit for it, then you can't take it as forgiveness under PPP.
Right, you can't get both. You cannot double dip. You can get one and then get the other, but you can't get them both simultaneously.
If a dentist is a C corporation, can he use this money to fund his retirement account?
So this is a really good question. I've seen it a couple times. So the answer is yes, but with conditions. So you can make contributions, employer side contributions to retirement plans. However, you know, let's just say was an employer matching plan. You can only count the match on the compensation up to 100,000, right? So if you're normally paying yourself $250, right, and you're making I'm just going to make up some numbers, a $10,000 retirement contribution, and you know now you have 100,000, you have to prorate that accordingly for purposes of PPP.
I terminated an employee during the layoff. Does that affect PPP forgiveness?
Not if you bring them back. If you bring them back by June 30th and you're complying with the 75% payroll requirement. In other words, you're using 75% of the loan proceeds for payroll purposes, and you don't decrease their salary by 25%, then you're okay.
Or if you're talking about you terminated them for cause because they were supposed to be terminated, and you replace them with another person, that's fine too. It doesn't have to be that body. So if you terminated them for valid reasons, then you don't have a problem with your PPP either, as long as you're still being you're just held to the standard that you submitted your loan documentations on, that was your salary, that was your salary combined.
Well, kind of related, does at-will employment still apply? If we hire another hygienist and not rehire the previous one, are they on the hook for the FMLA for the one that's not there?
So everybody's still at will. You still are allowed to make your own determinations. From what we can tell, the PPP, the only thing they care about is that your salary amount, that you were honest on how many people and what your salaries were, and you're putting everyone back to work. So if it's that person that you're not hiring, you're still allowed. It's an at-will place. So as long as you're not discriminating and you haven't fired anybody for discrimination reasons, and certainly, ADA reasons, because you think, they have COVID or whatever, you're okay. You still are allowed to run your company and still get loan forgiveness.
As an independent contractor dentist, if I get sick and need to stay home, is my employer required to hold my job for me?
It depends on your contract. So I assume with your independent contract, you have a contract that certainly probably says that, yes, that they have to. I'm sure it has termination provisions. It has certain things like that. So it is, an independent contractor is really totally contract based. So you almost have to look to the terms of your contract to what they can and can't do.
What if they have no written contract?
And if you have no written contract, shame on you, first of all. But if you have no written contract, then you're kind of at will and you put yourself at risk. I mean, then they can the employer is the one that's in charge. So generally, most independent contractors have entered into some sort of contract. And I guess you could go back and look at the terms of your contract, the oral terms of your contract prior to would rule, but it would be one of those things where there's a little more leeway on for the employer.
Can the dentist hire a family member and have them do real work in the office, even if they didn't work for them before?
So I've had this question too, and I think generally the answer is yes. I mean, if you have, say, a spouse who's licensed perhaps to do the work, right, of a hygienist, then yes, you can, because again, it's the full-time equivalent, right? If it's front desk work and that's what, they're trained to do, or they've done that in the past, it becomes a lot easier to justify that to the bank and to the SBA. But I would be careful with that, right? That falls under the broad counsel of taking a conservative approach.
We have a few on loan forgiveness here. Are monies forgiven for PPP eligibility on fractional basis, or do you need to reach the 75% of loan total for any forgiveness? So
our understanding so far is that it's going to be pro rata, right? So it'll be reduced, but not eliminated, right? So for example, if you reduce salary, by more than 20%, the amount of the forgiveness is going to be reduced dollar for dollar by the amount you reduce the salary. So it won't be eliminated. It's not necessarily an all or nothing.
We have received PPP money already, but are not back to work as yet. We have started paying the staff from the PPP money. 8 weeks runs out the third week of June. Do we have to pay out of pocket for the rest of June?
Yeah, I'm sorry. You want to run that through one more time, Ted? That was a
Well,
long.
the 8-week period runs out before the end of June, so they want to know if they are responsible for the final, what is left of June out of their own pocket.
Oh, yes.
Yes.
Yeah.
For PPP loan forgiveness, is it gross or net income in the calculation?
For PPP loan forgiveness, is it gross or net income? Well, the PPP is based on the payroll, right? So not in terms of what the forgiveness is. So it really doesn't, net income shouldn't come into play, net or gross.
If you meet the 75% payroll threshold, but can't quite use up all the other 25% for eligible expenses, what will happen?
You'd have a choice, right? You either take it as a loan, or you would return the money. You can take it as a loan, and then it's I think it's a 24-month term, right, at 1%. So for the most part, I mean, I'd recommend to people you just sit on that money at 1%, right, and use it for what you have to use it for, and then pay it back, in 24 months.
Employers with less than 50 employees are subject to 12-week FMLA requirement or just the 2-week sick leave.
You want to try that one more time?
Employers with less than 50 employees, are they subject to the 12-week FMLA requirement or just a 2-week sick leave?
They're required. They're both. You have both. They're different standards. The FMLA has not been expanded to all the things under the FMLA. The FMLA is only for if you have children that you're doing, but yes, you will. If you're under 50 and you do have to do both.
Can you fire employees after 8 weeks of PPP to avoid having to comply with FMLA rules?
That's a good question, right?
Can you fire them?
If you bring them back and you satisfy the PPP requirements, right? But you want to avoid the FMLA. I suppose you could,
yeah,
right?
Everybody's at will, so definitely you could, after you satisfy your PPP and you've paid them and you have the protection, certainly they're at will, so you can do what you want. Now, there's certainly that problem where they may ask when you bring them back during the PPP for the FMLA, and once they're on it, they're on it. You can't, if they're at home, so for instance, you're at week 8 of the PPP repayment and they ask for the FMLA leave, you're still going to have to give them that 12 weeks. You can't just suddenly, when the PPP dries up, say you're fired, because once they're on FMLA leave, they're protected. So you got to write it out after that.
And that's a good question too, in terms of there is no guidance in terms of how the act is written. It states you have to bring back the full-time equivalent employees, or the required number of full-time equivalent employees before June 30, right? So it doesn't say, say June 20th, and then you could let them go before June 30. So I'd be careful there, because the SBA may look at that and say, well, you didn't bring them back, right? And we need to keep an eye out for additional guidance there.
I know we talked about special cases with employees. How should you handle an employee that has a doctor's note stating that they have a medical condition, immunosuppression, that makes them high risk to return to work?
So, can you give that to me one more time?
How would you handle an employee that has a doctor's note stating that they're immunosuppressed, which makes them high risk for returning to work?
Well, so then we're back to the ADA guidelines. So if then it depends on what they do. So we're back to, they've asked for some sort of accommodation, right? And can you accommodate their job? So if you can't, then there's nothing that they can do. So let's say that they're a hygienist and you have to come in and you're immunosuppressant, and you have to say, well, under ADA rules, we've complied with Osha, we've given all the standards, we're following everything we can. We can't reasonably accommodate you in your job, and we're gonna have to let you go and hire somebody else. You just need to make sure that you protect yourself in understanding that they're asking for an accommodation, right, that can't be done. You don't have to, just because somebody's afraid, if you are doing everything that you're supposed to do, and just because they're high risk, if you cannot accommodate their disability, you don't suddenly have to under the new law.
Can we pay rent ahead for 3 months from PPP to use up the 25% within 8 weeks if we have to?
So that's a good question. And while it's not specifically addressed, right, and we're waiting on further guidance, and we'd expect it to come on prepayments, it goes to that issue I was saying about whether or not it's something that's incurred or something that is actually paid. We do not think that you'll be able to use it for prepayments, but I would hold on that pending further guidance from the SBA.
The data used to provide the amount for my PPP loan came from 2019. In December of 2019, I had an employee quit. I have not been able to replace her as of yet. What implications are there for my loan forgiveness?
So it will impact your loan if you used her in the calculation for determining the amount of your PPP. So the SBA right now kind of looks at it and has said, primarily, I think because of the rush that this came out in, you know, that regardless of circumstances, these are the rules. So they're not going to allow you to, you know, to keep that money. You certainly have to continue to try to replace her, but in theory, your PPP forgiveness will be reduced accordingly.
Right. If we need to close again in the fall and employees are getting unemployment now, will they be eligible to get unemployment again within the same calendar year?
Yes, I think that the government's going to let them get unemployment. They've only expanded unemployment. I would be surprised if it doesn't continue to be expanded. I think back when there was a whole, under the Obama administration, when there was a whole unemployment issue, they had unemployment up to like 18 months. So I would be surprised if they don't.
Are dentists required to pay part-time employees who cannot return due to childcare? Does this fall into the cap of $200 a day?
So if you are bringing people back to work and you offer and you decide that, and they say, yes, I want to stay home because I have these children and I'm part-time, absolutely, they're still covered. It's that, but it's a weirder calculation. It's less than that money because there's different hours and it's that different math equation that they've made super hard.
I've been paying my employees since mid-March while I've been closed. I just received my PPP loan. If I must remain closed according to the governor until the end of May, that will be 11 weeks I've paid them. Should I furlough them now and rehire them by June the 30th to conserve my money?
Yeah, that's a really good question, right? Because you're only going to get 8 weeks of forgiveness. So you'd have to look at the individual numbers, right, to calculate them. But my inclination would be yes, as long as when you plan it out, you can still comply. Spend all the PPP with 75% on payroll and 25% on other expenses. But you'd really have to dig into the individual numbers in that case.
If I had an employee quit prior to March the 5th and I've hired a new employee, can she accept the job and then immediately within a week take FMLA if she cannot find childcare?
I think there's isn't under expanded MLA, they have to be with you for 30 days.
Yeah, there's 30, yeah, there's a 30-day requirement even under the expanded one. You have to be working for 30 days before you're allowed the FMLA.
Can unemployment benefits be extended based on no caregiver for a child with special needs?
That wouldn't be unemployment, that would be under FMLA.
Yeah.
Right.
Right.
Yeah. Yeah. They would, in that case, they wouldn't, if the job is open and available for them, they wouldn't qualify for unemployment, but they likely would qualify under a FMLA.
I received my PPP loan 2 weeks ago. I have not used it as yet because we have been unable to work. I have a total of 5 people on staff, including myself. In a week and a half, if I do payroll, I will only have 3 people on payroll, including myself. The other 2 people do not want to come back until the stay-at-home order is lifted. Can you advise me regarding payroll in order to maximize loan forgiveness?
So that gets into a little bit of the unemployment and whether they would get that. I mean, let's assume for a second that they're not concerned about unemployment. They just don't want to come back, right?
Right.
So your forgiveness will be reduced, but in theory, you're spending less on payroll, right? Now, if they're requesting because of some FMLA related purpose, and then you end up having to pay them, and that would either be forgivable or you could recover that under a payroll tax credit. But certainly, keep in mind in general, the idea here is, to pay the employees. So if you get the money, but you're not paying the employees, the government's going to want you to pay that back or return it.
Or you can pay them and they can stay at home and you can start the FMLA running, assuming that they're staying home because they have childcare issues.
Sure. And you can also, if you had to, pay the other employees more, perhaps, right, if they're willing to take on more hours.
You could get creative with that.
Yeah.
All right. Well, I know that Amy has a time commitment here, so I think we're going to bring these questions to a close at this point. I want to thank Amy and Jordan for all they've done for us today. I hope you've answered as many questions as possible. I would say to our viewers that this program will be available to download from YouTube in 48 hours. And we will be giving 1 hour CE credit, and the certificates will be emailed to you as they're produced. Thank you very much, and have a good evening.
Thank you, Ted.
Thank you.